Good afternoon and welcome to the Appellate Division, First Department. We have more than 7 hours of argument time requested, so I'm going to give you my usual spiel. Please ask for the time that you need, not the time that you want, understanding that the time is for you, not for the court. So if your argument is so brilliant that my colleagues have more questions, I let the time roll. Okay? First case on the calendar. Bakus versus 676 East 179th Street. Okay. 5 and 1 and 4. G. Alaya is submitted. Gavalanes versus 919 ground lease.
Your Honor, unless there are specific questions, I'm fine.
Okay, and respondent?
Same thing, Your Honor.
Okay. Questions?
Nope.
Have a seat and wait until, no, have a seat and wait till the end of the calendar, then you can leave. Okay. I don't blame, no, it's all right. I don't blame you. It's a holiday weekend. I get it. All right. People versus Yanil Heredia Gomez. Submit. Bank of America versus Sands.
Oh,
Submit. Ambase Corporation versus 111 West 57th Street.
Good morning, Your Honor, or good afternoon, Your Honor. 8 and 4, please, with the
Okay? 7 and 2 and 8. People versus Brandon Monegro. Submitted. People versus XREL Christopher Boyle versus Magnally Litty. Okay? 6 and 2 and 7. U.S. Bank versus Marino. Any, oh, you're alone, so 5 minutes it is. Okay. De La Rosa versus Isabella Geriatric. Okay. 3? Okay. 5 and 2 and 3. Let's do 5 and 1 in light of the 3. I don't think you need so much time. People versus James Carr. Submitted. Zelmanovich versus Eastmore owners. Okay. 4 and 1 and 4. Ventura versus Ahmed. Okay, I don't think you have a respondent, so. Okay,
I'm good.
all right. Have a seat and wait until the end of the calendar. That case is a submit. People versus Marcus Mcgichi. Okay. 5 and 1 and 5. Campbell versus New York City Health and Hospitals. Okay. 5 and 2 and 4. MLN New York Inc. versus Lou.
4 and 2, please.
Okay.
Good afternoon, Your Honor. 3 minutes.
All right. 4 and 1 and 3. People versus DeAndre Holman. Submitted. Kepley versus Loeb is submitted. First case on the calendar, Bakus versus 676 East 79th Street. You may proceed.
Good afternoon, Your Honors. May it please the Court, I'm colleague Geriatric of Leon RPC, attorneys for appellant. Your Honor, ours is not an argument as to apportionment of liability, and is not merely about notice. Rather, it's whether the facts of this case invoke a violation of Industrial Code 23 1.5C3 altogether. Despite being a non-delegable duty, 1.5C3 should not be held to impose liability on an owner where the owner did not provide the equipment or tool in question, did not instruct the claimant to use the tool in question, was not made aware of any defect in this tool brought by a separate party, nor was supervising or controlling the manner and method of the claimant's work. This is not to suggest that we are using any of these factors alone to argue this 2416 claim, but that collectively this demonstrates that appellant lacked any involvement with the tool or overarching incident.
So, counsel, we can agree that under 241-6, there's a non-delegable duty on the owner's part, right?
Yeah.
And the industrial code provisions that you're talking about do require notice. Is that your position?
I would say yes, Your Honor.
And is it enough that the plaintiff may have made some sort of, or is it necessary that the plaintiff have to complain about this, or is it enough that they were made aware through the third-party defendants being present on the at the job site?
I think that's exactly the point we're trying to make. It's not merely we're arguing that the respondent, upon seeing that the grinder lacked a guard, did not tell his employer. Rather, it's also critical that this grinder in the first place did not belong to the owner or the employer. It's not as if they could have inspected it earlier, and it's not as if that they instructed the respondent specifically to use this grinder. The grinder was bought by a separate party. We feel that these facts are material.
Let's start with part one, which is notice to the employer. Wasn't the employer working alongside the plaintiff right there, Mr. Peters, who is the owner of Rudy?
Actually, by the testimony of the respondent themselves, the employer was out of the room when they used the grinder, and the employee never brought to the employer's attention the grinder in the first place, nor its lack of a guard.
Is it
There's also testimony that the owner was supervising the work.
However, the testimony was that the
The owner told him to use this grinder that was brought by a welder who was needed in order to break down this boiler. Isn't that right?
I would respectfully disagree on
Really?
per the record 90.
The welder had to be brought in because this tank was so thick that it needed a welder to cut through it, to break it apart, to take it out of the basement. That's what happened in this case,
Correct.
right?
Yes.
Okay, and that grinder didn't belong to the plaintiff, did it?
No.
That grinder was brought by the welder who was hired by Rudy Peters.
The
That's
grind.
what the record shows.
Yes.
And if I'm incorrect, tell me where in the record it says someone else brought the welder to the site.
That is not our argument, Your Honor.
Okay.
It's that the grinder was not an employee of Rudy Services, of the...
That doesn't matter. They hired the welder. The welder brought this equipment that had no guard, and they allowed one of their employees to use it. In fact, he was directed to use it because it was the only piece of equipment that could cut through this very thick boiler. Isn't that what the record shows?
The record shows that the grinder was the only one that was brought. However,
That wasn't my question. My question was, doesn't the record show that the only tool on site that could cut through this boiler was this grinder that had no guard?
yes, Your Honor, I'm agreeing with you. I'm saying that was the only grinder brought. That was the only grinder on the site to be used. However, respectfully,
and it was the only tool that could be used to complete the job, right? To do the job.
to the plaintiff's knowledge, yes. However, the testimony...
Was there any other testimony that said there was any other equipment available to the plaintiff that he was told about that he refused to use for no good reason? Is there anything in the record that meets that criteria, which is what our case law requires?
No, Your Honor. However, I would say that under Cabral v. Rockefeller, it's still a question of prior notice at the time of the accident. How would there have been prior notice?
Thank you. You'll have time on rebuttal. Is that okay, Judge? You may proceed.
Good afternoon. May it please the court.
I
Vincent,
never want to cut off one of my colleagues.
and
Go ahead.
absolutely neither would I.
You may proceed.
But to Justice Pittsburgh's question, 1.5C3.
Counsel, could you just make your appearance for the record?
Oh, I'm sorry. May it please the court, Vincent Chirico for the plaintiff respondent. 23-1.5C3 absolutely does not have a notice requirement. That is this court's Toy case in which this court said if they had a notice requirement, the liability against an owner would be practical.
But counsel, the grinder lacked a safeguard, correct?
Correct.
And everyone could see that, correct?
That's undisputed in the record. And not only that, but to Judge Gonzalez's question earlier, not only was the employer working alongside, but the record is absolutely clear that the employer directed the workers to use the welder's tools and that this grinder was the only one that could do the job, to Judge Manzanet's.
Well, so if we're going to be talking about notice, because that's obviously what your adversary is placing their most specific argument on, and one requires notice, one says upon discovery, but they're functionally equivalent, right? Because we're talking about whether or not they knew. And our case law may support the issue that there had to be some sort of complaint. Is it different now because the actual employer was actually present seeing this unguarded grinder, and so that satisfies notice?
I would say not only is that correct, Your Honor, but also the fact that the notice question that may apply to 9.2a is notice to anyone in the chain of construction. And here, there's no question that the employer, at the very least, provided the tools and had the opportunity to inspect this grinder before it was being used on site and didn't take that opportunity. Therefore, pursuant to at least 1.5C3, there's clear liability in this case. We could debate whether 1.5C1 is general or specific. We could debate whether 9.2 requires the kind of notice that this record contains, but there's no debate that 1.5C3 applies, and therefore, for those reasons, we believe that the decision below, at least as to that point, should be affirmed.
So, counsel,
Would you, go ahead.
going at the issue of notice from a different perspective, is the physical presence of an employer sufficient to constitute actual notice where the tool is being used at his direction? Is that enough?
I would say that it is.
Or do you have to make a proper complaint, a spoken complaint or a written complaint?
No, Your Honor, I would say that it is. And in fact, the Mcgichi case indicates such that when the employer had some kind of notice, that suffices for purposes, in this case, of 9.2a.
Thank you.
Thank you.
You have 1 minute.
Yes. Thank you, Your Honors. Your Honors, all I'd like to say on rebuttal is that the language of this very court was that plaintiff must deduce evidence of prior notice at the time of the accident. It is our belief that the testimony depicted that the employer, not even the owner, but even the employer, had not once shown to been having inspected the tool, having been informed anything to do with the tool.
Are we not charged to see what there is to be seen? I mean, it was clear as day that this grinder had no guard. It's not like you have to go really far. All you have to do is look at it, and you see that it has no guard. And he was directed by that employer to use the equipment. So I don't understand your argument.
Argument is that the respondent determined that he should use the tool, but was not directed to use it. He was not.
Well, that's not exactly what the plaintiff said, right?
I believe it is on record 92 to 96 of the appeal.
He said that the only tool available on site to cut through this was that grinder. So there's no question he had to use that grinder.
I believe he came to that conclusion, Your Honor, but he is not.
No, not that he came to that conclusion. There was no other equipment available to do the job. So unless you can tell me and show to me through record site what equipment was available for him to complete his job, then your argument is nothing but speculation. So tell me, where in the record is there evidence of any other tool that could cut through that boiler? Is there?
There's not, Your Honors.
Thank you. Have a good day. Ambase Corporation versus 111 West 57th Street.
Thank you.
7 minutes.
Good afternoon, Your Honors. Craig Flanders from Blank Rome for the appellants. This is a single issue appeal from a series of summary judgments with dozens of issues on appeal. And the reason why we narrowed the focus to this one issue is because it deals with collectability of hundreds of millions of dollars here. This is a case arising out of an investment in a skyscraper development deal. Our client put in tens of millions of dollars, and there are two primary claims in the case. They had an absolute right to be cashed out, an equity put right, to be bought out by the other member, and when they exercised that and the other member did not honor that equity put right, they used their position as a manager, engaged in a violation of the implied covenant of good faith to work with the lenders to essentially engage in a foreclosure scheme to wipe everybody's equity out so that our client could not collect. And what this deals with is whether two individuals, principals, Kevin Maloney and Michael Stern, are going to be held to their personal obligations as indemnitors under a specific instrument in which they agreed to that very liability. And I want to point to record.
Referring to the limited joinder.
Yes, I am. So that's record 829.
In that limited joinder, it uses the word for cause. How should we interpret that?
Sure. So cause is a capitalized word, and it borrows the definition from 8.10C. Cause is defined as it just borrows the definition. So essentially, there's two indemnity provisions. The very first one, which we call the cause predicate, which Your Honor refers to, was actually ignored below in favor of just skipping to the second provision. The first provision is the focus of our appeal because it's the most straightforward. What does cause include? It includes material breaches by manager of the operating agreement that causes damage to investor or company. So you have Stern and Maloney, indemnitors, indemnifying company investor indemnities for a breach by manager that is neither an indemnitor or an indemnity. It's straightforward based on the plain language English. We just want to hold them to their obligations. And what do respondents try to do? They want to talk about anything but this joinder. You don't see them mention it much in their pleading. They want to skip to the 8.7 indemnity, which is a completely independent indemnity obligation. They want to talk about the conflicts with alleged waiver or exculpation clauses. Here's why those don't apply. Because first of all, this is breach of implied covenant of good faith and fair dealing. That's what the manager action, the strict foreclosure, the implied covenant of good faith, that is not waivable. So the court doesn't need to spend a lot of time looking at exculpation for this cause predicate because it's an unwaivable contractual obligation. They want to come in and say that indemnifying for a breach of implied covenant of good faith would somehow conflict with a waiver that couldn't possibly apply. The waiver they rely on in 8.5 doesn't apply to Stern and Maloney. It only applies to members, not their principals. So it also doesn't apply on its face. They have this first party versus third party red herring. Well, in first party versus third party, when that is discussed and there's a presumption under Delaware law and does it apply, and those are issues in the briefs, that's a red herring on this cause predicate because this is not first party. This is Stern and Maloney, indemnitors. I'm going to repeat myself a little bit just because it's so important. This is company investor as indemnities. I am not asking that these individuals be held to indemnify for a contract in which they are a party. Not the indemnitors are not a party to it. The manager is a party to an operating agreement with investor and company, not the indemnitors. So this is not first party liability. And if you look at the trial court decision, you will see that all they're talking about is 8.7b. They hop over the most important, straightforward. This appeal arguably comes down to this single sentence. It's pretty straightforward. Now, if we even get to 8.7b, which is completely independent, it works differently.
Wait, you said the sentence. Which
Yeah.
sentence?
Yes.
Yes, so that is record.
So that we're all on the same page.
We're all looking for
Thank you
it.
for pausing, so that I can make that clear. So it's 829 of the record, and what I'm referring to is Romanet 1, which is the first of two indemnity obligations. Unlike Romanet 2, it doesn't join the indemnity obligations of the underlying operating
And
agreement.
it seemed like the decision below focused only on sub 2.
That's right,
And
he
seemed
skipped
to
over.
completely ignore sub 1.
That's correct, and they behave in different ways. So sub 2 is joining an existing operating agreement indemnity obligation. Sub 1 is a direct indemnity obligation. It's independent based on this instrument. This instrument itself is an indemnity agreement. You'll note on 829 at the bottom, that's the signature of Michael Stern and Kevin Maloney, some of the most sophisticated developers in this city. They have in-house counsel teams. They have access to outside counsel of many sophisticated
We are
firms.
not unfamiliar.
Yes, so I understand, Your Honor, and there have been prior appeals, and there are still appeals. These individuals are sophisticated parties that sign their personal names saying they were going to indemnify and defend our client and the company for material breaches causing material damage. It's undisputed, and this is very important. It is undisputed on this appeal that both the equity put right breach and the breach of implied covenant are material breaches that cause material damage. It's not even disputed between the parties. So we know that there's a trigger for indemnity under cause. A material breach is also a trigger for indemnity under 8.7b. They want.
What is your main argument, because you're running out of time,
Yes.
to defeat their position that the two principals get out under this indemnification?
Well, our main argument is that they agreed to pick up this liability and to allow them out from indemnity liability would require modifying the agreement. It's just,
Under which subsection?
well, it's under both subsections, but what I'm focusing on is primarily 1, because that is much cleaner in a 7-minute discussion, not because of 8.7b is unimportant, but it just doesn't have.
If we were
all-
to just be interpreting, just taking their argument at face value, if we were to be interpreting subsection 2, is that their argument in your understanding? Is that their argument for the third-party indemnification as it's interpreted under Delaware law? And are you saying that even if we were to accept that is in fact Delaware law, it doesn't matter because subsection 1 basically, as you have said, has the indemnification party to party, investor to?
Yeah, I am saying, as Your Honor crafted it at the end, that is our argument, but also 8.7b, under the PJT case in Delaware, which had an identical provision, materially identical to the indemnity provision here, the Delaware Chancery, Judge Lasser, a very respected judge in Delaware Chancery, recently, just before oral argument on summary judgment here, said that a materially identical provision to 8.7b covers first-party claims. And that was cited at oral argument. It's not mentioned in the decision. In respondents' opposition, they don't even deny that it's the same. Instead, what they're constantly trying to do is shift the focus to sponsor as the indemnitor. This appeal is about Stern and Maloney as indemnitors, not sponsor. Thank you.
Counsel?
May it please the court, Elon Dobbs of Katsky Korins for respondents. I want to go to the first Romanet on the joinder, which is record page 829. And what it says that Maloney and Stern agreed to indemnify and hold the company, investors affiliated persons, Atlantic's affiliated persons harmless on a joint and several basis with each other and sponsor. So both of these indemnification provisions in this joinder are joint and several. with Maloney and sponsor. So this puts on sponsor an indemnification obligation.
But it doesn't wipe out the principal's obligation.
No, it doesn't
Which
wipe.
is what the principals continue to try to do and argue.
No, that's not so. What the principals are arguing is that sponsor has an indemnification obligation here. It says it in black and white, jointly and severally, but that doesn't mean first-party liability. The agreement deals with the first-party liability of sponsor as
So what we
manager.
have to look at is the terms of the agreement and determine whether it makes sense. Yes, it's true that indemnification usually, typically, is for third-party claims, but not always, and we have cases where it's not a third-party claim. So the question is, I'm still talking, so the question is whether there is some language here that tends to show that evinces this is only third party, or is there language here that fudges it, that makes it ambiguous?
There's no argument here that it's ambiguous. What there is.
Well, the court is looking at this from scratch, so we can determine there's an ambiguity. So I'm asking you a question.
What I say, which is what's in our brief, is that this argument very carefully delineates the circumstances under which the sponsor is liable, and then it joins Maloney and Stern to the sponsor's indemnification obligations, which are dealt with separately. There is 8.5, which details the circumstances under which the members are liable to one another. Then there is section 8.6, A and B. A details sponsors' liability to third parties, and what does it say? It says, and principals to the extent of the limited joinder. In 8.6B, 8.6B says, which covers sponsors' liability to the other members and the company. It doesn't reference the limited joinder.
How about
They
section
say,
8.10C of the joint venture agreement, which includes 7 enumerated examples, including where the manager breached its obligations under any other agreement with the company, and such a breach has caused material damage to the company or investor, which is pled here. So, why is it difficult to imagine that in this situation, this would apply to a third-party claim?
Because it would only apply to a third-party claim. 8.10 is not a liability provision. It is the circumstances that will allow sponsor to be removed. The agreement has a distinct and self-contained section that deals with when.
We're not talking about removal of the sponsor, we're talking about indemnification.
No, precisely. And so when you the sponsor is not liable for the sponsor is liable for what it's liable under 8.6.
So I'm just wondering. I'm just wondering because we have this on record 829. We have this joinder. We have where signed by Stern and Maloney individually. What does that mean?
It means that they're.
If it's not going to be interpreted that there's this first party claim, then what does it mean?
What they're saying is that this is a full-blown unlimited financial guarantee of all damages that the sponsor would incur. And it's using the word indemnification, which is used separately from the words liability, which are spelled out.
Indemnification has a very definite meaning in our legal lexicon, right?
Correct.
So we can't just throw that word around to mean something we want it to mean on a given day.
And the Delaware courts are very clear that unless it is express, and this is on page 28 to 30.
Which is why I am suggesting it's ambiguous, because it doesn't seem to me, speaking only for myself, to be express.
Well, what I would say to that is if it's ambiguous, you need to take the following into consideration. In the lower court, the principals of Ambase said that they never would have signed on to this had this stuff not been in the agreement. It wasn't there. Number two, they didn't raise this massively consequential argument until their third pleading in this case. So what does that tell you about whether the parties believed that there was a personal, an unlimited personal guarantee? A very simple way to make the principals liable for the damages is through a personal guarantee. This is, and that is it is it turns the concept of limited liability upside down to render the principals personally liable.
You know
And if
how
you're
many
going-
times we get that argument in this courtroom? Do you know how many times I have heard that particular, oh, the entire business world is gonna fall down if you decide this?
Respectfully, that's not what I'm saying, Justice Manzanet. What I'm saying is that
I'm Justice Manzanet, not Mrs.
I
Manzanet.
said Justice Manzanet, Your
Okay.
Honor. I would never.
Right.
What we're saying here is that the Delaware courts have said that in order to do this, it would be very easy to do this by making them a party, by obtaining a guarantee, which is something that every transactional lawyer, as the Delaware courts say, knows how to obtain.
They signed this form, what does it mean?
It means they're joining in the sponsor's indemnification obligations, and
Why did they need to do that? Why, I mean,
in
this
case-
form seemed to indicate that they would be held personally liable, together with the sponsors, jointly and severally, which means we have to determine who's responsible for what, right?
Respectfully, if they had done that, they would have used the word "be personally liable."
Counsel, if we find plaintiff's interpretation of subsection I to apply only to first-party claims reasonable, and if we find your interpretation that it applies only to third-party claims reasonable, isn't that ambiguous?
That is the definition of ambiguity, yes.
Thank you.
How would you interpret the PJT case as it applies here?
The what?
The PJT case, the one from Delaware?
You know, there's nothing in the PJT case about what the agreement at issue said in its entirety. And so we don't, and plaintiffs didn't go and find the agreement. What you have here, and this is the thing.
Do we ever have the entire
You have in the
agreement
record, in our submissions below, we pulled the agreements and we put them in the record because it mattered what the agreement said. And what the agreements say in those, in other words, when the Delaware courts have held that indemnification provisions cover first-party claims, they either expressly state it, it's either the indemnification that is allowed under the statutory provision of the manager by the company, or there's no other provision that would be rendered meaningless by the interpretation of the indemnity provision as covering first-party claims.
Counsel, PJT dealt with post-trial decision and not a summary judgment.
And it awarded only attorney's fees, which is the only thing that's ever been awarded under any of these cases, because when they interpret these to cover first-party claims, it has only ever involved attorney's fees. And this agreement has an attorney's fees shifting provision, which the courts have said over and over again militates against interpreting indemnification provisions as covering first-party claims.
12.11, we got it. Thank you.
Thank you. So I want to address the guarantee point. A guarantee and an indemnity are two separate instruments. They're sort of cousins. They can behave with the same net result in certain circumstances, but a guarantee is an obligation to stand for a principle to perform under the agreement. Indemnity is a reimbursement remedy. So this doesn't, we're not asking them to come in, we're not asking that Stern and Maloney come in and buy the shares, a la the equity put right. We're not asking that they come in and object to the strict foreclosure. We're asking that they make investor and company whole on the loss or damage. It's a reimbursement right, and that's precisely what is stated in the agreement. And if they wanted to say something different, we don't, under the interpretation of respondents, literally every indemnity would have to be called a guarantee if there's any reference in the indemnity to an underlying contract. That is not how it works. This is a reimbursement right for a defined set of issues. So I want to address the issue with the ambiguity just because it came up during argument. We would submit that if first party and third party are covered by the cause predicate, that's not an ambiguity. We're not saying it only covers first party claims. We're saying it covers.
What about your adversary's position that if it was intended to be first party, it would have said something like personally liable or things like that?
Well, that goes to the idea of a guarantee is what I think what he was driving at here. How you know they want to be personally liable? Their signatures at the bottom, and then they signed a document which starts with principals hereby represent, warrant, covenant, and agree to indemnify and hold harmless company investors. So they are raising their right hand, sophisticated individuals saying they want to be liable. The lead-in paragraph to this joinder says why they would do this. It actually recites, like in wherefore style, as to why they would do it. It says they're making certain representations personally for the benefit of investor and company. So it does say that they're personally liable here. You don't have to say that it's a guarantee. This joint and several business, this is not even an argument they made at the trial level. Once they realized that a court was actually going to not skip over, hopefully, the first predicate and look at that independently, they came up with this new argument for the first time on appeal that joint and several somehow means that the Romanet 1's all about sponsor indemnity. Sponsor's not a signatory to this instrument. Joint and several just denotes that the plaintiff can sue all parties at once.
It says with each other and with sponsor, I think is what he was harping on.
Correct. They're joint and several, so they could all be named at the same time. You don't have to exhaust remedies against one before going to another. But it doesn't, they didn't cite one case for this interpretation that joint and several somehow means that all of the joint and several parties must be coterminous in their liability vis-a-vis the indemnity. In fact, most joint and several situations—
Throughout the process of the engagement between these parties, have the principals signed for and acted on behalf of the sponsors unilaterally?
The principals had the right to sign for the manager. Yes, they were in control of the manager and the sponsor unilaterally. They had the controlling interest.
So that they're signing a document, this joinder document, which includes the sponsor in the language, we're really talking about them.
Your Honor, respectfully, that is not the case. It's and there's a famous case in New York that says everyone in business knows that when you want to bind a company, you sign on behalf of the company, and when you want to sign personally, you sign personally. There's no such thing as a third-party obligee. The only signatories to
Well, they're saying that although the principals are the ones who signed this joinder agreement, that the sponsors are equally liable.
But the sponsor didn't sign it. They signed it.
That was why I asked you the question.
Yeah.
So let me ask it again.
Okay.
Right? So are the principals here permitted to sign this agreement and basically say, okay, so we're going to indemnify, but we're including the sponsors, right? And they're signing for them essentially by their signature then.
They had the authority to sign. They did not sign on behalf of the sponsor. It says individually after Michael Stern and Kevin Maloney that it is universal that when parties sign individually, it does not bind on behalf of the
So then the
entity.
inclusion of the sponsors in the joinder language means what then?
All it does is it's relational in terms of allocation of how a claim can be brought by the indemnity. That the extent of the indemnitor liability on behalf of Stern and Maloney is joint in several with whatever liability the sponsor has. It does not mean that those liabilities are coterminous. That's why the law of contribution exists, because defendants get sued jointly and severally, and then they go after each other, like comparative negligence, for example, saying, no, you're 60%, you're 40%. Under this reading, the word joint and several would mean everybody always has to be equal. That's not what joint and several means, and they haven't cited any case for that.
Thank you. People versus XREL Christopher Boyle versus Maganelli versus Litty. Maganelli Litty, sorry. You may proceed.
Good afternoon, Your Honors. May it please the court, Shane Magnetti for the appellant. This case is a procedural morass that began as a habeas proceeding seeking only petitioner's release. It was converted into an Article 78 proceeding in a default order despite clear confusion over the status of the case, and Supreme Court proceeded to issue a mandamus writ directing specific changes to attorney visitation protocols at RESH. Along the way, there was a host of procedural errors, any one of which warrant this court's reversal. In the first place, Supreme Court abused its discretion in denying the motion to vacate the conversion order. There was no so ordered due date in effect for DOC's motion submission, and even assuming they could have defaulted on a motion for which there was no deadline, DOC offered an eminently reasonable excuse for the
You have
default.
till whenever to respond to a motion?
Well, they have
No,
until
that's not the case.
well, they have until the court so orders the deadline because they need to have a
Because
benchmark.
there are in set guidelines for when you're supposed to respond to motions in our court system.
To default on a motion, there should be a clear benchmark.
Counsel, I'm asking you a direct question. Are there no set guidelines for responses to motions in our court system?
I'm
The
not
answer
aware,
to
Your
that
Honor.
is yes,
Okay.
okay?
Yes, Your Honor. But
All right.
even if we set aside that there's no court-ordered deadline,
Let's set aside that there's like a set date when you're supposed to respond to a motion.
sure. So even then, DOC still had a reasonable excuse for its default. DOC offered to submit its deadline on a certain date. Petitioner responded that there is no motion to convert.
Because the petitioner controls the court's calendar.
Well, the point is on a motion to
No, the
vacate-
point is that if there is confusion, it is on you, the litigant, to seek direction directly from the court, not through banter between co-counsel.
not when DOC reasonably believed that the motion was no longer pending. So in addition to the
On the
fact,
basis of what? What was there on the court system that said that it wasn't pending?
there was an order of dismissal on the docket that Justice Engeron issued that denied the motion to convert.
I don't even know how it ended up in front of Engeron when there was a motion pending before another judge. I'm not even gonna deal with that issue because that smells to me like judge shopping. So we're not gonna deal with that because there's no reason why another judge should have had their hands on this case. None.
Sure, and that may well be the case, Your Honor, but the point is, it
And
created...
most of us who are in the system know that if there's a judge assigned, all matters go to the same judge. So the moment it goes to another judge, that should have alerted the bells. Something's not right. Let's make sure we're on all footing here. That wasn't done.
No, that was not done, but nevertheless, I think you have to, looking at this as a whole, petitioner responded to the proposed deadline that there's no motion to convert pending.
Okay, why don't we talk about the substance of the issue? Tell me why it's okay to keep attorneys locked in a room to wait until corrections decides to bring their client for an interview. Tell me why that's okay.
That is okay because there are now several alternatives to that under the amended protocol.
That's okay. What you just said, that's okay. It's okay to keep a professional attorney locked in a room they can't get out of without a means of communication if something goes wrong, without access to a bathroom. That's okay to treat attorneys as though they are prisoners within our prison system when they go to visit their clients. That's okay?
That is okay here, Your Honor, because if you look at the evidence in this record, the legal visitor who came to visit this petitioner was locked in that room for 14 minutes. There's no evidence that anyone is being locked in these rooms for a prolonged period of time.
Counsel, isn't there a difference between how attorneys visiting clients are treated in other facilities within Rikers? Isn't there a disparity? And isn't this a unit where incarcerated people who have assaulted someone within the facility are held?
That's correct. And
So is this an indirect way of punishing the defendant by punishing the attorney and subjecting the attorney to conditions that none of us here would find acceptable?
No,
Especially when there's the existence of an equipped family waiting area at the facility.
Yes.
Of course, it's not a way to indirectly punish attorneys. The reason why attorneys wait in a locked area is because this facility is the enhanced supervision facility, and as Your Honor pointed out, it houses detainees who have a history of jail-based violence, and the attorney waiting room abuts areas through which these detainees are frequently escorted, keeping the area locked to make sure that nobody wanders around the
But as my
facility.
colleague indicated, to the extent that there is a family waiting room that has the proper facilities, in this situation, from what the record is telling us, the objection to having the attorneys there was budgetary. How is that acceptable? How does that affect the right to counsel? How does that serve as a disincentive to attorneys to represent defendants who are accused of violence within the facility?
So two points, Your Honor. So attorneys are able to wait in that area 4 days per week. They can schedule.
No, but 4 days a week is real different from everybody else. Let me just find my pages. 4 days a week, it's 8 hours a day for 4 days a week, as opposed to 12 hours a day, 7 days a week at the other Rikers facilities. That is a curtailment of the right to counsel, is it not?
It is not, because even then, counsel can still schedule a virtual.
I'm doing math in my head, and I know
All right,
it's not
we're not
complicated.
going to have this debate. You'll have time on rebuttal.
Thank you.
You may proceed.
Thank you. Good afternoon. May it please the court. Dorothy Weldon, New York County Defender Services, for petitioner respondent Kelvin Williams. This court should affirm the Supreme Court's order for two reasons. First, because Judge Neubauer properly exercised her discretion, converting the matter to the habeas proceeding to an Article 78. And second, because the Supreme Court's final order was appropriately tailored to remedy unconstitutional legal visit conditions at Resch. Now, to begin,
Direct how they had to achieve equity between the varying facilities at Rikers?
the Supreme Court directed three things. One was that attorneys at Resch have to be treated the same way as in every other facility. Now, as a part of that, the court also ordered that the family visit waiting area be available during all regularly scheduled hours that attorneys are allowed to visit their clients. And I'll jump right into this point because I think it is very important to do the math here, right? By the department's own policies, attorneys are permitted to be visiting with their clients, preparing for trial and for other critical advocacy in their criminal cases 84 hours a week. That's 8 to 8, 7 days a week. In contrast, at Resch, the changes that the department made to their policy only allow attorneys to use this family waiting area, which, as the panel has pointed out, is available, has all of these basic human needs the department is able to meet in every other waiting room.
How does the facility's discretionary authority play into that? And are they, would they be able to justify whatever discretion that they're exercising due to security reasons?
Well, 2 points to that. First, I'll just address the department's discretion more generally, and then specifically address the security issues, because those are important too. Just with respect to the Department of Corrections' discretion generally, the Supreme Court did not divest the department of its broad discretion to run legal visit protocol on Rikers Island.
That's why I asked you what I asked you.
But what the court did was essentially say that the Department of Correction cannot single out this one facility with harmful and unnecessary burdens without sufficient justification. And certainly, to get to the security point, that was not a sufficient justification. For one, if you
Was
look
budgetary reasons a sufficient justification?
Absolutely not. And I think Klosterman, perhaps, I'm going to really butcher this language, so please excuse the paraphrasing. But if the government comes before the court and says that budgetary reasons are the reason why they have to violate people's constitutional rights, that's just not a particularly forceful defense, number one. Number two is that with respect to security, look at the arguments the department was making below. They're saying that the real security issue is that family members might mix with attorneys, which makes no sense, given that they then made changes that only allow a situation where family members and attorneys have to wait at the same time, right? It doesn't make sense for them to say that it's somehow less secure for attorneys to wait in this area, which again, have bathrooms.
To be clear, because this needs to be clear. In this family waiting area, in this highly sensitive facility, right, with extra needs for security because of the level of the crimes of the inmates, right? They are allowed to visit with family amongst other families, correct?
That's correct.
So that somebody else's family is sitting at the table next door, so that this client that everybody all of a sudden is a major risk to, we can't have that person speak with their lawyer there, that person gets to visit with their family member next to other family members. So this isn't about security.
That's absolutely correct, Your Honor, right?
Okay.
We really think it's about costs, which again is just not persuasive, and the department certainly didn't flesh out that argument below.
And it would seem that if you allow the family, the attorney's visits to happen in this space, it would cost less money because you're already operating the family space for visits. But now you have to man another area where people are not happy because lawyers are being treated like criminals.
That's absolutely.
And being locked in a room they can't get out of, and that they have no access to a phone in.
100%, Your Honor. No access to a phone, water, bathrooms, vending machines, a reasonable means or available means to call for help. The conditions there are rough, to put it mildly. And before I forget, I do want to just go back to the math.
Conversion, can you get, also, don't forget the conversion part, converting this to an Article 78.
Of course. Just very, very quickly, the 32-hour window that the department is talking about, 4 of those hours don't even overlap with the standard attorney visit window. And for what it's worth, half of those hours are on the weekend. So when the department's making changes, 2/3 of the time, the choice is still exactly the same. Either get locked in or no visit at all. And just, I don't want to speed up too much, but I see I am running out of time, and I do want to address Your Honor's point, and of course, the broader matter of conversion, which is that the Supreme Court did not abuse its discretion when it declined to reopen that issue based on the department's untimely objections. And I want to just briefly, if I can, walk the court through really key.
You don't have enough time. We need you to get to the heart of the argument because we know what happened. You don't need to give us the dates on this day that happened. We know what happened.
The heart of the argument, Your Honor, is that the Department of Correction was given repeated notice and opportunity to raise these issues. They did not do so, and they never provided a reasonable or credible excuse for their own inaction in this case in figuring out what was going on, whether or not they were confused, right? This inaction.
Well, look, to be fair to the other side, you guys are the ones who created the confusion. You don't have the right to say there's no motion, only the court does. So you own that, okay?
I take Your Honor's.
You own that.
I take Your Honor's point, but a reasonable attorney, the Department of Correction, had to take reasonable efforts to understand and meet their own obligations, particularly in a situation where the court ordered litigation to proceed, said, DOC, when are you going to respond to this motion? They chose a deadline, failed to meet it, and then they proceeded to do nothing until the Supreme Court had fully moved on to the issues at the heart of this case that we've just been discussing, of course, the unconstitutional conditions at Resch. Now,
And counsel, just to go back, now, when the court issued the order, the court did not direct the Department of Corrections with respect to how to implement access, how to allocate resources. They did not do that at all.
that's right. There's no granular, explaining to the department exactly how they have to go through things step by step. They're not divesting them of discretion. They're just saying you have to treat this facility the same as everywhere else. And if I could have 5 more seconds to conclude.
Just 5.
Thank you. It's just to say, of course, the Department of Correction wants unlimited discretion, but the unfortunate and tragic lesson that we keep learning as a city is that there have to be guardrails on the department, especially when it comes to protecting the vulnerable, the rights of the vulnerable people in their custody. So for all of these reasons, we respectfully request that this court affirm the Supreme Court. Thank you.
You have 2 minutes, counsel.
Thank you, Your Honor. I'd like to pick up with Justice Kennedy's question. The court did strip DOC of discretion here in terms of how to, because counsel conceded in their motion to convert at page 294 of the record that there were, quote, myriad ways that DOC could afford pretrial detainees their right to counsel. For example, by bringing attorneys to the Resch facility only once the client was ready to be produced, by staffing a different waiting area that would not need to be locked. But the court went ahead and directed DOC to require legal visitors to wait in the family area at all times.
Your people said, problem solved, everything's been corrected, there's no issues anymore, you don't have to do anything, and that wasn't true.
Well,
So your recitation of how this all went down is not exactly accurate.
no, I disagree, Your Honor. There was.
I'm sure you do.
So this was something that they had proposed, to be allowed to wait in the family waiting room only when it's staffed, and that's the change that they implemented. But the fact is that they conceded that there's multiple ways that DOC could have addressed this constitutional harm, and mandamus relief exists to compel the performance of a legal duty, not to direct how it is to be performed.
And right to counsel is a legal duty, providing
Sure.
that is. But we have your arguments and your briefs and the record. Thank you so much.
Thank you.
U.S. Bank versus Marino.
May it please the court, Louis Levithan of Knuckles and Manfro for plaintiff appellant. I respectfully submit that the lower court erred in granting defendants cross motion tolling interest and denying.
Let me ask you a question about that, right? Because from what I can tell in the record, there was at least a 5-year period of delay where referees were being appointed and your client was making these motions to substitute the referee because for whatever reason they had to withdraw. They weren't able to continue as a referee. And that was a 5-year period where interest was accruing. Why is that the defendant's problem?
Well, I respectfully submit that interest cannot be imputed to plaintiff because plaintiff did not select the referee, and for unfortunate.
Why is it defendant's problem?
Because the.
Why does it take 9 months to put in a referee says I can't do it? Okay, so from the moment that you get that letter, you immediately submit a motion for a new referee. When I look at this record, there's like 9 and 10 months between the communication that I can't be your referee before you move again. That's on you.
Your Honor, while there is some time
And
between
after
some
the
of the
second
motions.
time, you should have been able to just punch a button on your computer and spit out a new motion substituting the names. It wasn't rocket science.
Your Honor,
right?
while there may be a.
I mean, counsel, 11 years from when plaintiff first sought an order of reference until it moved for a judgment of foreclosure.
Because none of the
The amount
referees
of
would accept
interest
the
that
appointment.
accrued, the amount of interest that accrued was above what was actually owed.
I understand it's a significant amount of interest, and I'm not even disputing the tolling that occurred and that the court ordered from March 2020, I'm sorry, from November 2020 to June of 2023. What I'm disputing is the fact that all of the interest was told during the need for plaintiff to file 5 motions for successor referees. It was not plaintiff's
Why
fault
should the
that prior
defendant,
referees did not accept the
why
appointment.
should the defendant have to bear that though? Why?
Defendant
You're in
maintained use
control
and
of the,
occupancy
you
of
are
the
in
property.
control of the prosecution of this action. And you haven't answered my question of why it took you so long to submit 3 motions for new referees. The first one was appointed, we can go through it.
Yes.
The first one was appointed in 2012, and you were told in August of 2013 he couldn't act as referee, but you waited until November to move.
Your Honor, no, the first motion was in September of 2013, was filed, and it was granted in November of 2013. The second motion was filed in July of 2014 and was granted in November of 2014. The next motion was May of
I
2015.
have the dates.
Yes,
I
Your
have
Honor,
them.
I just wanted to
And
clarify
I think
the
that
record.
they are delayed.
Your Honor, while there may have been some delay in the
And so
filing
why
of the motions,
should
it is not-
the defendant pay for that?
defendants maintain use and occupancy of the property for 16 years without having made a mortgage payment. I don't think under the
Right, and
circumstances
that's
here-
fine, but we're talking about the interest that accrued during the period of time where it took for you to get the right referee, right? And there was a period of time, specifically when the court, for whatever reason, reappointed Cavallo, and that was in September of 2017. What was the delay between that time and when? Didn't you get this order and notice, wait a minute, this was the first referee who said they couldn't do it. What are we doing?
There was also during that time an intervening order to show cause, I believe, that was filed by a defendant. However, plaintiff does not appoint the referee. Plaintiff does not choose the referee.
Counsel, but you stay on top of it. You stay on top of it as the attorney in the law firm. I mean, Akbar, there's a 4-year gap between Akbar's 2019 appointment and his May 12, 2023.
And I'm not disputing the
Okay,
tolling
and
of
then
interest
we have
during that
Adler.
time.
He submits a report that nobody ever acted upon.
Your Honor, there was no report submitted by referee Adler. Referee Adler, the judge stated, the lower court stated that there was a 2016 report by referee Adler. However, referee Adler was already removed and replaced by referee Jednek in September of 2015.
Let's talk about Adler, because actually, there was a letter from Adler indicating unable to accept the appointment as the referee because of an insufficient fee.
Your Honor, the fee for the referee is set in the motion for the order of reference by the court. Plaintiff does not have authority over that.
Let's go
I
back
want
to
to
Akbar.
reference
Let's go back to, if I can just, I'm almost done. Let's go back to Akbar. What was the explanation for the 4-year gap? Because appointed in 2019, but didn't submit the report until 2023. So what was the explanation given for that,
Well, I mean, we did
4-year
have the
delay?
pandemic during that time period, of course. I am not, my office was not counsel of record during that time period. I don't know necessarily why the report
Not that
wasn't.
the pandemic would have influenced that, because
Well,
what we're talking about is counting numbers from documents.
Well, Your Honor, foreclosures were stayed for a time period here. And in any event, during that, I'm not disputing the tolling for that time period. I'm
All right,
disputing the
my
tolling.
colleague has a question.
So, counsel, with respect to the referee's report, which was premised on the Ross affidavit,
Yes.
in looking at the record, you are challenging the failure to confirm the referee's report, right?
As well, yes, Your Honor.
In looking at the record, it's pitiful. I hate to put it in those terms, but the forms created by specialized loan servancy are deficient. They don't have anything but a name on them, Mr. Marino's name. They have no address. They do not indicate they don't have a mailing address for him. Putting that aside, they don't have an address for the subject premises, which are the whole issue, that's the whole issue behind this, right? That there's
So, Your Honor, some of the pages do, in fact, have the address of the premises on them.
a lot of them don't, and
In Exhibit F, there is not one reference to the
Exhibit
subject
F
property.
is pathetic. I mean, I
At all.
hate to put it in those terms, but
If
I don't understand.
reference-
I don't understand why the plaintiff bank would accept this type of form from an entity that it was paying.
I understand, Your Honor. On page 82 of the record, it does state Moses R. Marino and the address of 1186
I'm looking
Jackson
at record
Avenue.
page 64. Simple, just one page. All it has is client SLS, loan number is blank, mortgagor name, okay, Mr. Marino, current interest rate per diem, prepared. That's it.
And I would just add to that, when you're talking about the affidavit in support of the amount due, it specifically references Exhibit F as the proof of the payment history and a summary of the amounts due. And then when we get to Exhibit F, there's no reference to any particular property. How do we know it's this subject property and not any other property?
Well, I think the affidavit authenticates the record. Paragraphs 3 and 4 of the affidavit set
It
forth.
doesn't answer that question, counsel. It doesn't answer the question as to the missing information.
Well, I respectfully disagree, Your Honor, and that the affidavit itself authenticates the record as pertaining to this action and the foreclosure of this property.
Thank you.
And I thank the court for their time.
Thank you so much. De La Rosa versus Isabella Geriatric Center. You may proceed, sir.
Good afternoon, Your Honor. May it please the court. My name is Brennan Breland. I'm with Kaufman, Borges, and Ryan for the defendant appellant, Isabella Geriatric Center. This court should reverse the order below because the EDTPA provides immunity for the nursing home in this case. The court is intimately familiar with the briefing and the record, so I want to direct the court's attention to the two most recent cases decided by this court on EDTPA immunity.
Counsel, before you talk about the two cases, so the EDTPA has three prongs, right, that have to be satisfied. And we know that with respect to prong one, that's fine. This is a healthcare facility that provided a care in response to the COVID pandemic, and prong two was impacted by the pandemic. But with respect to prong three, as to health care services provided in good faith, to what extent do we look at the fact that there were citations imposed on the facility by the Department of Health shortly after the death of this person?
Your Honor, I would point to the case law we cited in our reply, but I don't have it in front of me, that notes that there's not a requirement for strict compliance with the rules, with the COVID regulations in order to determine whether there's good faith efforts to comply.
So,
Because otherwise it would be,
Is there a requirement to comply with any of your own you establish protocols to deal with a deadly virus to a compromised community. Can we agree on that? Because
Yes, sure.
people in nursing homes are compromised. They typically have several comorbidities, right? So that adherence to protocols is even more important in this setting. Can we agree on that?
yes, Your Honor, I'm not arguing that.
So is there any evidence that this nursing home even followed its own protocols?
Your Honor, I would reference.
And please don't talk to me about your recreation affidavit, because that to me was a joke. Yeah. A joke. You have a nursing home. You've got the director of the nursing home. I don't have an affidavit from that person. I have the affidavit from a recreation person. How much recreation was going on during COVID?
Your Honor,
How much recreation was going on during COVID
None.
that I get an affidavit from someone who probably wasn't even in the building at the time?
Your Honor, respectfully,
Did
Ms.
she say she was in the building at the time?
Ms. Feliz, her affidavit indicates that she had personal knowledge of the
It
policies and
doesn't
the
tell
ethics.
me whether she worked in the building at the relevant time. Did she work with this patient? I mean, what are we doing? So now anybody in the nursing home could fill out an affidavit, and is that sufficient to get you dismissal?
It's been held dozens of times by this court.
I've been on those cases that I've dismissed, and the affidavit I get is not from a recreation person. It's from a nurse, the head of the department. This is a joke.
Your Honor, our reading of the law is that a person with knowledge of the policies being in
And look,
place-
if you want to be taken seriously, give us an affidavit from someone who's serious, right? Come on. Come on.
Your Honor, at this juncture, the record is the record.
Exactly. So at this dismissal stage, should I dismiss this case where a woman dies because it seems to me like the protocols that your own facility put in place weren't being followed, and that's likely how she got COVID? We don't know. But
Counsel,
what I do know is that the recreation affidavit tells me nothing. Nothing.
so counsel, going to the DOH violations, and again, they were issued subsequent to the decedent's demise. She passed away on April 4th of 2020. The violations were issued on the ones that I'm going to reference were issued on May 18th of 2020. So let's say within 6 weeks, more or less. One had to do with having no contact droplet precaution signs on the doors of several rooms at the facility. Also, importantly, staff members were observed on multiple occasions not using face masks on a unit designated by the facility as COVID-19 presumptive and non-COVID-19 residents. There also was a failure to follow the cohorting requirements that separated out people. These are very, very concerning violations. So how do we view those in light of your arguments?
Your Honor, if my memory serves, at least a few of those violations occurred after the death of Ms. Morrell.
I said that, yes,
Yes.
I acknowledge that, approximately 6 weeks.
Yes.
Yes. Is there a,
So we should assume they all happened on that, just on that day?
No, no.
On that 6 weeks after?
No, my argument is that it doesn't necessarily follow that they occurred before Mrs. Morrell's death.
did you provide anything to us or to the court below indicating that there was full compliance with COVID precautions? Does any, I mean, the recreation therapist really, I echo what my colleague said. I mean, not even a nurse?
Your Honor, our position is that the law doesn't require strict compliance with all
Right, we could,
regulations.
anybody, let's get the janitor to give us a, I mean, seriously. Next.
Good afternoon, Your Honors.
Bring that down. Yeah.
I'm a little short. Good afternoon, Your Honors. May it please the court. My name is Aparna Pujar from Napoli-Shkalnik, and I represent the plaintiff respondent in this case. Your Honor, this court should definitely affirm the lower court's decision because the
Devil's advocate, the evidence of the citations which occurred 6 weeks after are not likely to make its way into a trial evidence. So how do you establish that there was a problem before her death?
Your Honor, firstly, this is a pre-answer, this is a pre-discovery motion. We would need discovery. In fact, they have only provided us 150 pages of medical records. Plaintiff respondent lived there for 12 years, Your Honor, with only 33 notes. So we don't even have all the papers. So as this court...
Counsel, let me just ask you a question. In terms of the recent case law that's come out of this department, Midori, Holder, where it seems that if the facility can show that the patient's health was impacted by COVID-19, then the EDTPA applies. And in those particular cases, there were other factors. Someone had an ulcer, someone had some other comorbidity outside of just the COVID-19 virus. But what we have here is just the virus. How are you just going to distinguish these cases?
Yes, Your Honor. We can easily distinguish these cases because what those cases say is that you have to conclusively prove that due to the COVID, the decedent's health was affected. Due to the directives during pandemic times, their health was affected. Like Your Honors mentioned, the affirmation, the evidence they have submitted is from a therapeutic recreation specialist, not from a doctor. So it is their burden to show conclusively how the plaintiff respondent's health was affected due to COVID. Like how the 3 prongs were mentioned by Justice here. So these 3 prongs are not fulfilled. In fact, Holder says, the case Your Honor mentioned, that you need to conclusively prove, and that burden is on the appellant here, and that was not done in this case, Your Honor.
Thank you.
Okay. Your Honor, if there are no other questions, okay, thank you.
Thank you so much. You have 1 minute, counsel, for rebuttal.
Very briefly, Your Honor, I'd like to point out that the language in Holder requiring conclusive proof references the fact that in that case, the injury at issue was a pressure ulcer, and the conclusive proof was with regard to the attenuated relationship between COVID-19 care and the pressure ulcers. I would also point out that in the Maduri and Silva Rios cases, the language that this court put in its opinion, that you were on Justice Manzanet and you were on
I've
Justice
been on
Gonzalez,
several of these,
right?
yes.
That it said when the
But that's why and forgive me, you know this isn't personal. I hope you realize that.
I do, yes.
But
Got thick
look,
skin,
we want, it's just my personal feeling that if you're gonna come to the appellate court, come with the strongest hand, right? And a recreation specialist who wasn't even working at the time of the pandemic is not your strongest hand. And I'm sure there were a dozen other people that could have provided us with a much better affidavit that would have supported your argument a lot better. That's all I'm saying.
If I may make
Please,
reference to
I
the
took
to
up
the
your
two
time,
things.
I'm gonna give you more time. Go ahead.
The couple of items that I wanted to mention. In Silva Rios, the court noted that where plaintiffs sustained injuries and complications directly tied to COVID-19, this is not a situation where the plaintiff might be placed in the position of having to take the defendant's word for dispositive issues. That's the underlying rationale in Maduri as well. Those are the two most recent cases that this court has decided on the issue. I would like to mention the two most recent cases decided in the state of New York on this issue, both decided last week, one in the second department, one in the third department. The second department case is, I'm going to butcher this name, Cacace, C-A-C-A-C-E, 2026, New York Slip Opinion 01759. And the third department case is the estate of Middleton, 2026, New York Slip Opinion 01826. Both of these cases involve nursing home residents who acquired COVID-19 in the nursing home, died from it thereafter upon hospitalization externally. And in both cases, the appellate division reversed orders denying motions to dismiss on EDTPA immunity grounds. I'll specifically reference the estate of Middleton case out of the third department because the evidence submitted.
Go look it up, please. We got it. Thank you.
Thank you, Your Honor.
Zelmanovich versus Eastmore owners. You may proceed.
Good afternoon, Your Honors. Joseph Dimitrov Lishville-Cavo on behalf of Eastmore owners. The issue brought forward on appeal is very straightforward, and that is whether or not the respondent plaintiff pled discrimination in her amended complaint. Eastmore puts forward that the allegations put within the amended complaint, giving every favorable inference to the respondent, is palpably insufficient. To wit, respondent failed to cite any allegations in the amended complaint, any animus of behavior by the appellant indicating that their decision.
She said that she had complained about the person upstairs and the board did nothing about it. So she does specify a difference of treatment. So I don't think your recitation is accurate.
I apologize. What complaint? That there were steps above her?
She made complaints about the tenant above her. I don't answer your questions, you answer mine.
No, I didn't understand the question. I apologize,
right.
Your Honor. I would argue in that particular instance that the board actually did address that.
Well, she says that you didn't. So that to me is already an issue of fact, right? Or am I supposed to take the board's word for it over hers?
No.
No, so that's an issue of fact. There's an issue about whether she was treated differently. The complaints about her dog were taken very seriously. She was threatened with removal from the building.
But
her complaints, according to her, were not addressed. So that to me is an issue of fact.
And that could be under the idea of the defense of the business judgment rule for breach of fiduciary duty, putting different standards for the tenants at large within the cooperative.
So you agree that the motion to dismiss was properly denied?
No.
Because there are issues of fact here?
No. This is particularly addressed to the discrimination as to her alleged disability.
Well,
So
let's
the
get to that.
disability involves the dog.
But that would be
So,
akin
and you
to.
cannot separate them.
That would
I know
be-
you'd like to, but you can't, because she said, and she provided a letter from her doctor saying she needs an emotional support dog.
But allowing the complaints that were.
One complaint from one tenant.
Hundreds of complaints
from that one tenant, and all of the other residents around this woman say that's not true. So again, that is an issue of fact that does not permit you to get summary judgment.
And then,
Dismissal.
well, this is and then just also to add, in terms of the reasonable accommodation, once she forwarded that letter that my colleague spoke of to the housing, there wasn't a meeting. There wasn't anything that said, well, let's try to work something out, which is something that is maybe required to show that you attempted to do reasonable accommodation. And while we are at this plead-in stage, why isn't it enough for her to say, well, this is what happened, I submitted this, and I never heard from anybody?
Well, not to argue the facts that are outside of the actual complaint, attempts were made to meet with the plaintiff in order to address her concerns. However, plaintiff herself was
She couldn't make that date, and she tried to make another date, and it didn't happen.
correct. So communications had happened. Unfortunately, the meeting was unable to be
Right,
held.
but so we're
that
again, we're at the
dispositive?
plead-in stage.
Correct.
Right? So maybe on summary judgment after discovery and all of that has been flushed out, that's a different thing. But now at the pleading stage, why isn't it enough for her to say, this is what happened?
That is because according to the allegations in the pleadings, they are simply just a subjective interpretation of the.
All complaints are.
Well,
Every single one, yes.
no, that is correct.
My
Counsel,
colleague wants
I have
to
a
ask a
question for
question.
you.
Yes.
You know, what about the allegation that, as soon as, the tenant advised your client of her disability, she received the notice of default, and there was no legitimate reason to even issue that notice because the allegations, I should rather say the complaints, were false?
Her allegations that the complaint are false, but the board received complaints. The board acted on those complaints.
The board received a bunch of complaints from one tenant, just one.
Yes,
And it's the same tenant she complained about, which the board did nothing about.
as alleged
Right.
at the pleading stage.
Okay.
I
The red
understand.
light is on, you'll have time on rebuttal.
Thank you, Your Honor.
You may proceed.
Thank you. Good afternoon. May it please the court. Brian Mueller from Prior Cashman LLP for the respondent Blanche Zelmanovich.
Counsel, your client did complain about the noise from upstairs, correct?
She did, yes.
And in their reply argument, in their reply brief at 7, they say that the upstairs neighbor is not sufficiently similar to the plaintiff to be a proper comparator because the noise from the upstairs neighbors is not the same as the dog.
Yes, I think that
Did they do recordings of these? Are there any recordings on either side of this terrible noise?
well, in fact,
This barking dog that barks so incessantly that only the upstairs neighbor hears it.
in fact, we'll find out in discovery. We'll find out.
Do we know if they ever followed up on your client's complaint about the upstairs neighbor because they didn't address it in their brief?
We have no knowledge, and we'll find out in discovery, I hope, when we get there. One thing that's happening here on reply in particular is that we're mixing different species of discrimination for housing. It's not even addressed in their appeal, but this principally, our claims are related to a failure to make a reasonable accommodation. The elements of that are that you have a disability. We've alleged that. That you have notice given. We've alleged that. That you have a necessity for her to enjoy her home, to have an emotional support animal. That's been alleged. We have a refusal by them to provide a reasonable accommodation. Instead, they served a notice of default and a notice of termination. She's lived in this house since 2009. She's a shareholder in this.
So let's back up a minute, counsel. So in the summer of 2021, they request to meet with her. She says, I can't make this day. Let's try for another day. That never happens. Then for 4 months, no notice, no complaints about the dog. Then she serves the letter, and now there's more complaints about the dog, and she gets the default notice. Do I have that correct?
I look forward to discovery on that. That's accurate. Exactly right.
Gonzalez?
So, counsel, with respect to failure to make reasonable accommodations and failure to engage in an interactive process, how do we weigh the allegation of the petitioner, sorry, I'm calling her petitioner, plaintiff, that she brought her dog to a Petco class and then worked with a trainer and puts the dog in a doggy daycare as well. Is that to be viewed as a question of fact? Is that to be viewed positively, as in she's taking proactive efforts, or negatively, as in the dog is hopeless?
Well, we'll find out as this case goes on, but I would tell you the reason it's alleged is because we never wanted to be here. We did everything we could to satisfy this board. Everything we could. That's why it's alleged. Everything. I was involved. I asked her to do that because we didn't want litigation. We had litigation after they're trying to kick her out of her home that she's lived in since 2009. That's why we're here. Unless the court has anything else, thank you.
Thank you. You have 1 minute.
I'll briefly address one of the questions that was asked of your honors as to whether or not there are any recordings of barkings. There are. They have been exchanged in discovery. Discovery has been ongoing despite this pending appeal. And also, in regard to the reason.
Plaintiff also alleges that some of the complaints made about the dog occurred when the dog wasn't even in the building, correct?
That is
that
a
an
question
issue of fact?
But I can't
Well, if the
exactly
dog is at
rectify that.
daycare, you better believe she's gonna have that evidence. Because she's paying for that daycare.
Presumably. As far as the
So it
reasonable.
ain't free. It's not free.
As a
So
dog owner,
if the
I'm
dog
aware.
is at puppy daycare, trust me, she's paying.
Yeah, as a fellow dog owner, I'm
You know,
reasonably aware.
it's expensive.
But as far as the reasonable accommodation, the argument essentially comes down to plaintiffs saying that my dog, whether or not it actually is barking, causing the noise,
But it seems like you guys made the determination that the upstairs tenant was correct
based on the information
without,
received.
of only him.
No investigation, counsel.
Well, again.
That's what you say in your brief. It's not the same type of complaint. No rug upstairs, walking back and forth. That's not the same as a dog barking. You said that in your brief.
I would end on this, Your Honors. If this dog is an emotional support animal for purposes of the underlying disability alleged, the accommodation that plaintiff is requesting by allowing the dog to stay there would be akin to a seeing eye dog that is necessary for a blind resident who bit
No,
someone
that's not
and
the
abort.
standard, counsel.
I know, and I gotta
this.
tell you, that argument places you at risk of violation of the city human
ADA.
rights laws. So I would be very careful, and I would suggest that you guys review them again. Okay?
I hear you.
Because it is not, we think this tenant is correct, so therefore we can just ignore your request for accommodation. We don't even have to meet with you. We give you one date, you can't make that meeting, that's enough. That does not satisfy,
Understood.
okay? So just word to the wise. Have a good day. Ventura versus, no, that one's submitted. People versus Marquise versus, I always mess this up.
Mcgichi.
Marquise Mcgichi. Is that right? Okay. Sorry about mangling the name. And sir, you have 5 minutes.
May it please the court, my name is Noah Kinnickstein. I represent Marquez Mcgichi, who made an application for youthful offender treatment at his initial sentencing and was denied because the court at that time determined that the plea bargain was sufficient in that it took into consideration his youth. Although there's nothing in the record that indicates that statement except for the judge.
Counsel, let's pick it up from when after this case was remanded and we're talking about resentence, because yes, did this court not agree or that the YO was not placed on the record sufficiently initially? Then he came back for resentencing, and then there was another discussion about whether or not he should get YO status, right?
I'm sorry, I couldn't hear you so well. So one more time.
Was there a reconsideration as to whether or not Mr. Mcgichi should have been given youthful offender status? Was it only considered once, or was it considered twice?
So that's a little unclear, actually, in the record. The judge initially set up.
Okay, stop. The judge does not give him YO the first time. Defendants are not satisfied with the record that is made on that first time. You make a motion, the appellate division sends it back for a proper determination. It goes back. The court considers it again and basically says, I considered this the first time, but I didn't put it on the record. So here it is on the record.
Well, it's
Now, ask your question.
When it goes back that second time and the court places it on the record, the court actually says why this person was not entitled to youthful offender status, because of the seriousness of the crime, because of the history. Why isn't that sufficient? Why isn't that sufficient exercise of their discretion?
because when he goes back for the resentencing, the court reestablishes in the statement that because of the nature of the crime, the violence itself, she will not even consider it, period. She's not.
No, she doesn't say, I'm not going to consider it. She's saying, I have considered it. And because of the seriousness of the crime, I am not going to change my position from the first time. That's what she says.
I want to pick it up from there because she also talks about the multiple incidents, multiple victims, and that this prolonged course of conduct was not a lack of impulse control, but from an emerging adult, that it was not a lack of impulse control from an emerging adult, in light of the multiple incidents, the multiple victims, and the seriousness of the violence. All of those things was why it was denied.
That's true. She says that. But the point of youthful offender treatment is even in defendants who have committed very violent crimes.
Yes, let's talk about that. This is a conspiracy of 12 co-defendants who collectively committed 83 offenses. Of those 83 offenses, your client was charged with 38 of them.
And
of
this
those
is
38, 5 were shootings, of which your client was the shooter in 4 of them. So what did the judge miss? What did the judge miss?
The judge missed doing what the law requires, Your Honor, which is to have youthful offender treatment even for somebody who's committed.
Counsel, it's discretionary for a reason. It's mandatory that you review it, but not every person is going to get it, right?
There's no question about she has discretion to do it. But if you allow her to say that the crimes were so violent, I don't have to consider youthful offender treatment.
But she did.
That's not what she said. That is not what she said. She said, there was, to be clear, ample, very rigorous discussion about whether or not YO adjudication would be appropriate. And we discussed it. We conferenced it. The court made a record of it during the plea, but the court did not articulate it as it should have at the time of sentence. This is why we're back here. 12 co-defendant, 83 offenses, 38 counts of which is your client. As member of the Fast Money Gang, spanned over 8 incidents in New York County between February 23rd and April 29th of 2016. She took it into account, counsel.
No.
Like my colleague said, it's discretionary.
No, she didn't take it into account. She conflated the plea itself as the basis of considering youthful offender treatment.
Is one of the bases for whether or not someone's going to get youthful offender status the seriousness of the crime?
It can be, but you can't conflate the plea as a basis to dismiss the youthful offender treatment.
Thank you.
You do that, then every judge in this state can say, well, I took into consideration the
You know what?
plea
Youthful
bargain.
offender treatment is awarded in this county and in this state all the time.
It does.
Okay? So, you know, I'm not sure where that argument is going, but you'll have time on rebuttal. Did we miss anything here in terms of the gravity of the situation?
No, Your Honor.
This was like a 6-day rampage, right?
It was very serious.
Where these 12 co-defendants went around shooting at their rival gang members.
Correct, Your Honor.
Is that what was going on? They're
That is
just
correct.
shooting around like it's the Old West.
Correct, Your Honor. There were 6 shootings. He was involved in 4 of them. 1 of them involved a murder. It was a very serious crime over a long period of time.
Does the fact that the court erred on the first pass at youthful offender by not articulating on the reason, on the record why it was denied. Does that somehow taint what happened on the second appearance, where where the resentencings, where the considerations for YO was made?
No, Your Honor. The whole reason of resentencing was to fix this procedural error, because as the judge described in the plea deal, during plea sentence, the reason that she wasn't granting youthful offender was because of the serious and numerous amount of crimes this defendant had committed, but procedurally, she forgot to reiterate that during sentencing, which you must do as a procedural rule. So for resentencing, the judge corrected herself. She not only reiterated the reason she wasn't giving youthful offender, but she allowed defense to make another argument and listen to those arguments again.
Just one more. And defense was permitted to submit a report, a document, for the court to consider, in addition to what had been considered the first time. So the court had additional information to consider on this resentencing.
Correct, Your Honor.
So,
wait, Judge Bahati.
I guess I'm just thinking about the reason why someone is given youthful offender status, right? It's mainly because, as studies have shown, youth at that age, maybe their brains haven't formed all the way, they make impulsive decisions. And is it something that we should be looking more strongly at in terms of like, well, give these people, young people a chance? Or is there discretion left in that determination?
There is, of course, discretion, because there's different scenarios where youth offender is more appropriate than others. And this is a case where it's not very appropriate, because not only were these crimes very serious and numerous, but they took over a long period of time. So it wasn't like an impulsive action, which defendant took in the heat of the moment, but it was something that was premeditated and done repeatedly.
in deciding whether to accord YO status to a particular defendant, is the judge confined to looking only at the crime to which the defendant pled guilty, or is the judge allowed to look at all those incidents that were alleged in the indictment?
The judge is allowed to look at the entire circumstances of the crime and the situation, which this judge did do, and her explanation explains why she made these decisions.
Wasn't part of the reason that the court felt that YO was not appropriate was because she said it was this defendant who pulled the trigger on 5 of those shootings?
In 4 of them, Your Honor, but yes.
Okay. Yeah.
In addition to this, defendant's sentence is a result of a fairly negotiated voluntary plea agreement. He was facing 25 to life on the top charge before he accepted this plea deal, and he only received 16 years and 5 years of post-plea supervision.
You can't say only with 16
you can't.
years.
Compared to 25 years.
Okay, I mean, because how old is he, 24?
Yeah.
So, I mean, this is like 2/3 of his life already.
Yes, it is a very serious
talking
sentence.
about. So I don't want to talk about that lightly.
That's fair.
So why in light of the fact that he already has to deal with the plea to such a serious and violent charge, and the consequences that will come from that when he tries to re-enter society, why should we not consider reduction in light of his age?
In light of his age, because the judge did take his age into consideration when forming the sentence. It's much lower than what he could have received, not only because it's lower than the top charge, but because there was many different instances. For example, he was charged with 38 charges. So some of those charges, because they were for many different instances, could have been consecutive. So this sentence, though it is serious because of the seriousness of the crimes he committed, is very reduced to what he could have faced if he hadn't accepted this plea deal.
Okay.
If you have no further questions, I rest on my brief. Thank you.
Thank you.
YO treatment is to take into consideration the full parameters.
I gave you an extra minute since we I gave you an extra minute since we interrupted you so much.
I appreciate that.
Go ahead.
It's to take into consideration the full parameters of a young person acting against the law, even very severe acts, which no one is denying. What he did is horrible. But the question becomes, and the state has determined by law that we're going to stop for a second and we're going to say, who is this kid? Okay, 16 years old, just 16 years old. Okay, and he acts in a very irrational way in a very violent neighborhood. Okay, there are gangs. I'm not defending it. He did a horrible thing. He hurt people. But at the same time, we need to know where he's coming from a little bit more than just the crimes themselves. I want to leave you with this, which is the judge didn't say, I'm denying YO treatment. The judge said, I'm not even considering YO treatment. I'm not even going to listen to it, okay? And so she says, well, yeah, you filed some papers here and there, and what do you want? But she never really thought about it because she'd already made the determination. She said, even before you talk, it's out. It's not happening. The plea was the basis for me not allowing a
That was during the first go-around.
She restated it in the second. She said, I'm going with the same analysis I had the first time. That's what she said. You can read the both sentencing, and the thing is that the kid, my client, Mcgichi, when he went to prison, and I don't want to make more of this, this isn't like a fairy tale, okay? But something happened to him when he was in prison that showed that he was something other than this wild child, if you don't mind me saying, in a certain way, acted in a very, very belligerent and hostile and dangerous manner. Who is that kid? Who is he? That's what YO is there for. She can decide. I'm not saying she doesn't have the right to do it. I've said it all along. She has the actual discretion to make that determination. But you can't jump on his bones before he even gets an opportunity to put it forward. That's what's important here. And if I'm just going to say it one last time.
I will commit to you, this court is going to look at the record completely and will consider everything that had to be considered.
I believe you, Your Honor, but I want to say one thing, and then I'll sit down. If this judge's justification for denying YO, which is that the plea took into consideration his age, there's no more YO. Any judge can say that. Thanks so much.
Thank you. Campbell versus New York City Health and Hospital Corporation.
Good afternoon, Your Honors. May it please the court. My name is Michael Noonan, and I am the attorney for the appellant plaintiff here, Janice Campbell. The primary issue before this court is to find that the lower court decision granting summary judgment was an error, particularly on the basis that the assertion that the experts' elaboration of what the departures that led to the injury were, in fact, as the judge said below, a new theory.
Well, counsel, your expert said that a retrograde bladder fill should have been performed prior to separating the uterus from the adhesions to the bladder, right?
Yes.
And then the other expert, the defendant's expert, said that bladder injuries, including perforations, were common, and that the prior pelvic surgery left scanning. So is this, like, from a legal perspective, pretty open and shut, competing experts, no summary judgment?
I think that's pretty much the case, and I think, at least on the issue of whether there might have been a new theory offered, I think the case law I've cited to from this department, Acosta and White, shows that it doesn't have to be that you have to, maybe in a federal deposition of an expert, delineate every move, every step. That's not the purpose and the requirement of the Bill of Particulars in this court in this type of case. And in fact,
since a Bill of Particulars is typically set forth way before discovery and et cetera.
yeah, and the pleading, and I'd like to point out something about, it was suggested in the brief and below that this was not standard of care. That's not the basis for granting or denying. That's a disputed issue of who understands what standard of care is. It was suggested in the opposition brief that there was a total surprise about the use of retrofilling the bladder. And yet, in looking at the record, and when I deposed Dr. Shah, he said that.
Surprised based on Dr. Shah's EBT. Even he said that.
Yes, he said that. He conceded that using what was in place, meaning the Foley catheter, to inflate and give, dimension to the bladder, which with all of the 5 hours of operation, the difficulty.
On a surgery that was supposed to take 2.
Yes. And we pointed that out, and yet the decision below disregarded that, and yet it is founded in the record, it's founded in the testimony, and it's founded in the facts of the operative record, that in fact, this was a departure, that it was an option available that was not taken, and it was a proximate cause of this woman's very serious injuries that she had, and it's detailed with all the records I included, like 7 volumes and such, how many times she had to go back for restorative surgery and such. It was not an insignificant nick. This was a substantial.
No, this was a back to front cut.
Yes, it was.
Yeah, I mean, so this was not a nick.
And within the context of even the testimony is that they misjudged the size of the uterus, which affects understanding the dimensions of the organs here. And on top of the fact that you had well-known and anticipated problems with adhesions, that the use of giving dimension in the operative field to what we didn't want injured was the departure that the court below should have recognized and allowed this matter to proceed to trial. I'll reserve anything for a rebuttal.
You got it.
May it please the court, Alex Famelli for the city. Acknowledging certain claims that are not pressed here on appeal, we're left with 2 theories about the standard of care that appellant received. One about the lack of use of a surgical dive from the beginning of the procedure, and another one about the absence of an extra surgeon, a generalist, who Ms. Campbell surmises might have been able to render some kind of assistance.
In the bill of particulars, the plaintiff asserts that the failure to properly perform the total abdominal hysterectomy goes on to also say in using improper technique had been applied. Why isn't what the plaintiff's expert says in terms of inflating the bladder, why isn't that addressing specifically the technique? And so where's the surprise?
Well, I would even go further than what Your Honor has said, and I would say that sort of the closest that appellant comes to alleging anything about, for example, methylene blue, the use of the dye from the beginning, is where the appellant in the bill of particulars mentions a failure to properly and or timely visualize the operative field.
Right. That's like basic, right? You
Well,
don't
right.
cut somebody open, right, and perform surgery on an organ without knowing exactly where the organ is, what the contours of that organ is, and the doctor says that she anticipates, right, a problem because of the her prior history.
Any
Right?
point about the importance of visualizing the operative field is certainly well taken.
Right, and so why isn't that, how does that then equal surprise when you kind of just elucidate that with more facts and more medical jargon?
I think it is such an obvious point, if you don't mind me saying, that sort of any case in which there is a laceration of an organ, it seems to me that would ordinarily be pleaded in the complaint. And based on a couple of cases that we've cited.
Sorry, what would be normally pleaded?
That it would be entirely ordinary in any complaint,
The lack
any
of
bill of
operative
particulars, to say that there was an issue with the operative field. What we were looking for is for some sort of specific theory as to what it was that the doctor should have done differently. In this case, the theory that develops is that they should have used methylene blue from the beginning to be able to tell the tissues apart from the organs themselves. This is where the city's expert affidavit comes in and says, well, yes, If you want to use it for that purpose, I suppose you could try. But under the circumstances of this case, based on the amount of tissue that was there and the prior surgeries that this appellant had had, it wouldn't have been useful.
So you go in blind.
Well, no, of course not.
That's what the doctor is saying. Let's not do this test because that's really not going to be useful. It's not really going to tell us much. So we're going to do nothing and just go in and try to figure it out while we're there.
The expert affidavit said that it is not performed. It is not the standard of care, and that methylene blue is used for the purpose of determining whether there is a leak.
How about what Dr. Shah said? Shah, right? Yeah.
But my recollection of the deposition is that Dr. Shah acknowledges, as my friend says, that it could have been used. But I don't think that's the same thing as saying it is the standard of care or that it would have been effective.
But he confirms that had that been done, the outline of the bladder would have been better, right?
I didn't understand.
He says that.
If that's the case, I misunderstood the point that Dr. Shah was making. Certainly the decision below
Go ahead.
rested on the expert affidavit that was provided by the city. And the point I want to make about this is sort of
why isn't this an issue of fact between these two experts?
I would agree if there were one expert that had said red and another expert that had said blue.
But no, I'm sorry. I don't need an expert that says red and blue. Sometimes one says, yeah, red over here, blue over here, and there should be some pink, right? So it doesn't, they oftentimes experts will find areas upon which to agree, and then they just diverge on a particular issue. Why is that not the case here?
I think that's exactly how it works, but part of that is it's an evolving conversation. One expert may make a point, and then the other expert, as in this case, acknowledges that point, accounts for it, but says, in this particular case, it would not have been effective. That point was left unrebutted.
Yes, but we don't have reply, sir, reply, so that is not a fair argument because he would have had to make a motion and ask for permission to sir reply.
Our perspective on that is that it would have been appropriate to ask for a sir reply based on the fact that it was our adversaries who raised
Those are
this
hardly
in
ever
the first
granted, you know that, right?
place.
Hardly ever.
I may be a little bit luckier than most,
Judges
but
are like, "Oh, all right, enough, because then you'll come back and say the same thing, right? So eventually we've got to decide.
before I sit down, I just want to make the final point that we have it's been narrowed down to essentially two issues: about the dye and about the attending general surgeon. I appreciate the court's skepticism as to the dye point, but I would note that there doesn't seem to be any disagreement as.
I don't need two reasons. All I need is one. Okay? All I need is one. All right, but I hear you. Counsel, you've got a minute.
Briefly. It was my expert's opinion that they would retrofill the bladder. It didn't have to have dye. It just had to have normal saline. It was something that would give dimension, as Dr. Shai said, that you could get. This was an already in place Foley catheter. In fact, at the end, when they realized she was bleeding, that's what they did. But
in fact, they had to do something in order to figure out where the bleed was coming from.
Yeah.
Because the field is now
right. But
obscured.
they knew she had cut.
Yeah, because it was
and
filling
then
with
they
blood.
wanted to see with the blue where it was, and then they had to call in the surgeon to fix things.
Right.
So otherwise, I would rest on.
Thank you so much.
Thank you very
Have a
much
good
for
day,
your
gentlemen.
attention.
And happy holidays.
You too.
Last but not least, MLN New York Inc. versus Lou. See, you guys are batting cleanup.
Seems like I'm bound to clean up a lot before this court, so
I have nothing to do with that.
I'm not sure if that's a good thing or a bad thing.
Just so you know. All right, you may proceed, counsel.
Okay, thank you. May it please the court, good afternoon. Michael Cassell, I represent the respondent, Mr. Liu. I think the easiest starting point here, because I know it's an arbitration decision, is just to start, and let's focus on the damages. MLN argues multiple times, and they have a chart, it's on page 393, that the total disgorgement, the best case scenario for MLN, is $615,250. They say as of 2019, my client should disgorge 100%. That's $615,250. The award, however, gives MLN $707,600. $750. And I don't want to bore the court with the math, but the court found that my client got zero, nothing for his ownership interest, which is $372,500, and then had to disgorge $335 above that. That's $707,750, which exceeds the amount that, even based upon MLN's position, is the worst case scenario for my client. So on that basis alone, I should submit that the award should be set aside. It has no support at all, even based upon what MLN claims. Also, as we discussed in detail, just getting to the merits as to whether or not there was a faithless servant or some type of breach of fiduciary duty, MLN cited multiple cases, and we don't really disagree on the law. All of those cases make clear that a faithless servant only applies in 3 specific scenarios. None of those were satisfied here. None of those were demonstrated here. I know it's an arbitration decision. I get that. I know it's a high standard, but it's not an impossibility standard. This is an example. We have an award that's above and beyond what could possibly be awarded, and we have a situation where there's not a single case, none, 0 cases that has ever found a breach of fiduciary duty or a faithless servant under these facts.
Counsel, you have a situation here where your client shorted employees of their break money, the funds to which they were entitled, pocketed the money, and then fomented discord amongst the employees, saying that it wasn't he who was holding back the money, but rather his what would you call her? His
Co-owner.
Co-owner, thank you.
Okay, I agree.
I mean, that's pretty bad.
My client...
And the arbitrator looks at this and says, okay, you know what? $335,000 back, everything.
Well, it was $335 back and 0. My client lost $372,000 as to what he owned in the business. There's not a single case out there that says, even if he has to disgorge his prior, what he made, he disgorged what he made and got 0. The numbers are undisputed. That's $372,500. As far as that issue with the
But if his share of the business at the 20% was eaten up by the $335K, why was the arbitrator supposed to think about keeping his shares intact? Well, or his percentage of the business intact?
Well, the award itself, if you read through it, I mean, the numbers are undisputed. It's undisputed. The case started with my client seeking to get out of the business and get paid for his ownership interest. There's not a single case out there. It's even cited by MLN.
He rooked the workers. He took their money, pocketed the money, and then blamed it on the co-owner.
Actually, there was discussion about him discussing that. There's nothing in the record to show he ever took a penny from the co-workers, first of all.
Well, obviously there was, because Lee had to pay $22,000 in back pay.
He did underpay them, and that claim was waived, though. The MLN waived that.
I understand, but then don't stand there and say there's no reason at all for. Come on.
I mean, that goes.
You'll have time on
Thank you,
rebuttal.
Your Honor.
Your red light is on. You asked for 3 minutes.
Thank you, Your Honors. May it please the court. Michael Muley on behalf of the respondents, MLN and Ms. Susan Lee. Your Honor, on this appeal, we respectfully suggest that what the appellant is trying to do is reweigh the facts and have second-guess the arbitrator to overturn an arbitration decision.
More was done than just not paying workers for an hour, correct?
I mean,
he got people not to work at the restaurant, correct?
He
told people, let's sue for the back wages and give me 20% back. I mean, he did more than just.
There was a lot that went on here. This went on for 2.5 years and beyond. There's evidence from 9 witnesses. 4 witnesses talk about solicitation over a period of 2.5 years. He tried to undermine Ms. Susan Lee's management authority on numerous occasions, saying, don't listen to her, listen to me. He disrupted operations.
Your adversary's arguments regarding Mr. Liu's equity interest in the.
Yes, thank you, Your Honor. So first, he's mistaken on what the damages were. On R393, the worst case scenario of damages was $717,250. What it was the rational finding of the arbitrator was the $615,250 as was essentially what should have been disgorged. And from that amount, she took the equity interest, the $280,000, and subtracted that number and came up with $335,000.
So the number amount is the balance
Correct.
between the total amount less his equity and the resulting sum is what is due Ms. Lee.
That's right. So he essentially got a credit for his equity interest in that. And on top of that, he owed $28,174.75 for reimbursement, which...
She waived.
She waived.
No, that wasn't
That's not
a
what
waiver.
she
This was for the AAA fees that he had a front and that he didn't pay. So that was the other part of the arbitrator's award. So
What she waived was repayment
What she waived
of
was
of the fees.
of the
hours.
That's right,
the
for
hourly
the
wages.
workers. But that was something that he still did. It still caused disruption in the company. He disclosed confidential salary information. A lot of things occurred on this, Your Honors, and there's no basis for overturning the decision.
And he retaliated against employees.
He did. He fired them, and so, thank you.
Thank you. Counsel, you have 1 minute.
Sure. I'll just respond briefly to the math issue. If you look at the award, it sets forth, it's on page 32. My client's entitled to $280 for his equity interest, but he's also entitled to $92,500 for what he's owed for 2024 for his ownership interest. That amount of money makes it above and beyond the $615,250. So at a minimum, the number's off by $92,500. And lastly, as we submit in our papers, my client was there 5 years as a manager. There's isolated incidents. They don't rise to the level of the three enumerated types of
Counsel, you
conduct.
broke the law. Come on.
Broke the law? How? I'm sorry, Your Honor. How?
Aren't you supposed to pay workers their wages?
Your Honor, I've dealt with tons of underpaid cases. It doesn't make a manager have to disgorge profits. I mean, if that's the law, every single case where there was an FLSA case, the company pays, but for a manager to disgorge hundreds of thousands of dollars for $22,000 underpaid, there's not a single case out there that holds the manager have to disgorge profits for that situation.
Thank you.
Thank you for your time.
Happy holidays.